content carried in here is suitable for general family viewing.
It is Tuesday, the 8th of August 2023. Many thanks indeed for tuning in to Law Matters, a show that is informative and offers legal aid solution to what we face on our day-to-day lives. Tonight, we are looking into the issue of human rights and demonstration, escalating the conversation we had last week concerning demonstrations and the Constitution on what the law says. As we know, the MWANGI Kenya coalition has threatened to move to the International Criminal Court, accusing the state and the police of police brutality and causing deaths during the demonstration, and that will be part of our conversation tonight. Remember, you can send in your feedback on our social media platforms at KTV Kenya on Facebook, at KTV_Kenya on Twitter, and KTV Kenya on YouTube. My name is IRENE MWANGI, but before we get into the nitty-gritties and putting this discussion into perspective, let me allow my guest to introduce himself. Kindly.
Thank you very much for having me. My name is MAURICE OWUOR. I'm a lawyer by training, an advocate of the High Court of Kenya as well, and currently the Dean of the School of Law at DYSTAR University.
All right. Now, Dr. AJWANG, kindly tell us the issue concerning human rights and demonstrations. Where do these two issues cut across, especially at a time where in the country we have had political leaders and civil society causing an uproar concerning the issue of human rights and demonstration? Where do they cut across?
First, human rights are fundamental rights. They can also be referred to as basic rights. They are those rights without which individuals or society cannot lead a dignified life, and therefore they are important rights. Now, demonstration, picketing, assembly, petitioning are all fundamental rights. They are part of human rights. So therefore, one would say that human rights is the broader category, whereas the right to picket is an individual right within human rights.
Okay. Now, when we look into that perspective, we're having the talk about peaceful demonstrations, and it has been a term that has been thrown from either side, calling for peaceful demonstration, which calls the question onto what equates to a peaceful demonstration here in the country.
Now, the Constitution under Article 37 provides for the right to picket, the right to demonstrate, the right to assemble, and the right to petition. And the Constitution also envisages demonstrations as peaceful. Okay? So therefore, the right to demonstration is not absolute. In other words, there are limitations, but those limitations must also be in accordance with the law. And specifically, Article 24 does provide for limitations. But the important thing to note is that these limitations must be reasonable. They must be justifiable, particularly in a democratic society. So therefore, the limitations should not be arbitrary. You cannot, for example, just say that you have banned demonstrations. Okay? At the same time, one must also understand that there are duty bearers when demonstrations are taking place. And the duty bearer here would be the state. The state, under the Constitution, has the duty to ensure that there is protection of lives and property. The state is also, also has the duty to ensure that demonstrators are protected. And where there are elements within the the demonstration who are unruly or who are troublemakers, then it is up to the state to, it is up to the law enforcement agencies to identify such elements and deal with them. And because there has been, that sense, or that view that it is the demonstrators to, but the bigger role lies with the law enforcement agency to ensure that there is sufficient security, and also to ensure that they are able to identify any rogue element within the demonstrators. And I think that then would, would then possibly answer part of your question as to, in relation to peaceful demonstrations. The law envisages, actually, the demonstration is envisaged as peaceful. If it is not peaceful, then it turns into a riot.
Yeah.
So a demonstration, under the, under the law is expression by individuals, but in a manner which does not threaten the rights of others.
Now, you've mentioned about limitations that can give the state the reason to say there are no demonstrations in the country. What are some of the limitations, given that you've mentioned that they should be justifiable? What limitation can bar protests being held in the nation?
Well, if, for example, it comes to the attention of the police, and again, this must be well-founded, that the demonstrations from the word go is intended to basically, further, insecurity, and, for example, use the demonstration as a basis or as a platform to, destroy property or to threaten lives, then the police would have reason to, for example, limit the right to demonstration. But again, it must be, that must be done within the context of the Constitution. It must be reasonable. And reasonable here, therefore, means that there must be ground, valid ground, upon which the police would then, deem it fit to, for example, disperse. And even where the police has to disperse demonstrators, again, that must be within the confines of law. It must ensure that the fundamental rights and freedoms of individuals are still protected. And if you look at Article 25, Article 25 of the Constitution does provide for those rights which cannot be limited. 24 provides for the rights which can be limited. 25 provides for rights which cannot be limited. And among the rights which cannot be limited would be, for example, torture. I mean, there's freedom of torture. You cannot subject individuals to torture. You cannot subject them to inhuman and degrading treatment. You cannot basically, subject them to servitude. So therefore, even, for example, as you disperse a crowd, you must ensure that you must ensure that you use proportionate force. And therefore, issues of police brutality then negates the process of within the confines of law, stopping a demonstration or dispersing demonstrators. And I think there has been instances in recent times where, for example, police break into a house and beat up senseless, a mother and their children. So basically, that is a violation of human rights. And there's also been, instances where the police have been accused of torture. If, for example, you corner a demonstrator who is not armed, then what would require proportionate force would require that you get hold of him, and if he's not protesting, get him into your vehicle.
Okay.
But if, for example, he is protesting, then again you must just use, and he's not armed, then again you must just use reasonable force. But where you, hit the person falls on the ground, and you continue clobbering him senseless, then that would amount to torture.
Yeah.
It would amount to inhuman and degrading treatment. And therefore, those are, the freedom from such behavior is, that is where, there is no limitation. You cannot limit, such conduct.
Okay.
Such conduct is unlawful. It is unconstitutional from the very beginning.
Okay. Now, you partly touched on the responsibilities of the duty bearers in terms of what happens in demonstrations. Perhaps what now is the responsibilities of the demonstrators in themselves, because we have had cases of the protesters being told, you maintain peace and order, yet what we know is that the police officers, they have the duty to maintain peace and order in the nation. So which burden do the demonstrators carry when they are picketing?
Now, the demonstrators, again, the Constitution envisages that demonstrations, picketing, petitions are peaceful, that those who participate in these activities do not endanger the lives of others or threaten the rights of others. And therefore, that is a burden which a demonstrator would carry. But this burden should be carried individually. It should not be carried collectively. So that, for example, if you have 1,000 demonstrators and 5 of them are being unruly, you cannot tear gas the rest and disperse in the name of maintaining law and order.
Okay.
So therefore, I think it is important that the police or the state must just do what they are, what they are obligated to do by law, and that would then, and because you see, the security agencies have, they have the equipment and they have the resources to, even before the demonstration begin, they are able to, for example, know whether there is likelihood of the demonstration becoming unruly.
Yeah.
They're even able to identify within the crowd elements which may be unruly.
Yeah.
For example, you have demonstrators walking down the street, and you realize 2 of the demonstrators are, breaking into a shop, and the others continuing, then you cannot, for example, condemn the whole procession on the basis of these 2. So what would be required is the police to apprehend those 2 and charge them appropriately.
Then, what then are the facts concerning the demonstrations that we have had in the nation since the Moi era? Because when they get unruly, even if it's a group of people, the whole crowd gets dispersed. Does it mean that the state and the national police service then infringe the rights of demonstrators, because the police now fail to focus on the few elements that are causing disruption and disrupting the whole congregation in totality?
Yeah, and I think Article 245 and 24 that of the Constitution and the Police Act, respectively, does obligate the police to basically maintain law and order, and to do that using proportionate force. So the question of proportionality is key.
Yeah.
So where the police exceeds what would be proportionate, then that becomes an infringement on the rights and freedoms of those who are demonstrating.
Yeah.
And you will possibly agree that in many instances, if you look at the majority of the demonstrators, they basically are not armed.
Yeah.
And even where there are those who may appear to, be carrying what would possibly, amount to a dangerous, instrument or weapon, then it would be a stone. The police have sufficient resources to ensure that they disperse, they disarm, they demobilize, demonstrators where need arises. And again, I think the key requirement here is that they must act in a manner which is reasonable and which is justifiable. But where, for example, the police corner a helpless demonstrator who is on the ground, and 5 of them, unleash rungus on this demonstrator who is not carrying any arms, then they would be subjecting that demonstrator to torture and to inhuman and degrading treatment. And it would be a breach of both the Constitution and the Police Act.
Now, what has happened before in the country in terms of the demonstrations ending untimely? Because normally you will see the demonstrators moving either to Parliament or through the office of the President to present a petition. But many a times that the demonstrations, especially the political ones, do not get to that particular stage. Does it mean that now the police interfere with the right to demonstrations, given that some of these demonstrations are untimely? And is it a big failure on their part in that political demonstrations do not quite reach to the point where they agitate their causes or what they're calling for?
I think there are many instances where demonstrations have ended peacefully. And there are instances where very huge crowds have gathered, heard their leaders express themselves and dispersed peacefully. And I think there was even one which took place at the time when there were the Maandamano demonstrations. I think there was one which took place in Kibera, and the demonstrators went through the streets of Kibera, and businesses were opened, and the demonstrations ended, and they went back home. So therefore, there is a sense that the police, in instances, provoke demonstrators by either firing tear gas and unleashing the water cannons without provocation. And once that happens, then that demonstration will degenerate in appreciate what its mandate is or what its duty is. The state has resources. The state is conferred by the Constitution the right to protect lives and property. And again, I think maybe the state would be better off in appreciating that it is the citizens who have delegated power to the state. The Article 1 of the Constitution does provide for the sovereignty of the people. It is the people who are sovereign. It is the people who delegate power. It is the people who constitute the executive, and the judiciary and the and parliament. And therefore, the state should always have that at the back of their minds, and therefore act in a manner which does not appear to be, insensitive, because demonstrations are a unique a channel of expressing yourselves. And where the state is able to listen to the demonstrators, then they're in a better position to deal with the issues arising. But where you deny the demonstrators the platform, because you see demonstrators do not have offices, political offices, so therefore they don't have platforms or fora where they can express themselves. So, a state which is rational would seize the opportunity of hearing the people. And when you hear them, you can act accordingly, and therefore forestall many challenges and forestall many, unwanted consequences. But where the state becomes insensitive to the people and forgets that sovereignty belongs to the people, and also forgets that human rights are not conferred by the state. The state does not grant human rights. Human rights are inherent. You are born, entitled to human rights, and therefore, where the state behaves in a manner likely to suggest that they can give and take away, then that kind of state is on the wrong path. So therefore, I think that would be important.
Right. Thank you, Dr. Ajwang, for that particular perspective. But it is time to take our first break on this particular show. But do stay with us. We'll be back with much, much more on this.
That creates awareness on matters health and informs you on various diseases, their causes, treatment, prevention, coping, and support. So join me, Barry Michelle, every Thursday at 7:30 p.m. only on KUTV. You can also follow us on our social media platforms at KUTV Focus on Health on Facebook and also on YouTube, and Health Focus on Instagram, because your health is your wealth. Stay safe and stay healthy.
Kipindi hewani ni mitindo ya kipwani. Kama ilivyo kipindi hiki kinahusu nyimbo za taarab, chakacha, midwara, midundiko, bila kusahau mapishi. Ambao ndio uti wa mgongo wa pwani ya Afrika Mashariki.
Jamani, swahibu zangu mliopo maskani, hatuonani wenzangu, najua mwanitamani.
Hapa KUTV, nahodha mwendesha chombo cha baharini, yani ua linalonukia na kuvutia waridi tamu.
Thank you for staying with us. You're watching Low Matters. Tonight we're looking into the issue of human rights and violation. And this second segment of this particular show, we are looking into what are the rights that have been infringed during the demonstrations, and what rights should the state ensure that they guarantee to Kenyans, given that it is their inherent right as is. Now, Dr. Ajwang, we talked about the issue of who is supposed to do what and who is required to do what. But now contextualizing the discussion in terms of human rights, what are the human rights that the state should ensure that they protect during demonstrations? Because many a times that we hear cases of rights being infringed, but the common mwananchi does not understand which rights should the state ensure that I'm guaranteed to during picketing.
Now, during demonstrations, it is the right to demonstrate, the right to picket, the right to assemble, and the right to petition. These are the rights which, emerge directly from that context. But it is also important to appreciate that Article 37 should not be read in isolation. Violation of Article 37 does impact on other articles. For example, if you deny a person the right to demonstrate, then you effectively deny them freedom of expression.
Yeah.
If you deny a person the right to picket, you deny them the right to assemble and to associate and and conscience to hold certain thoughts, and the right to receive information and the right to impart information. And you'd also be infringing on their rights as sovereign, the people being the sovereign.
Yeah.
So therefore, you also you will be interfering with their sovereignty, and you'll also be violating the Constitution, which the state is also obligated or required to to respect and to adhere to. So therefore, there are very many rights which are violated when processions of protesters are dispersed violently. And if you look at the incidents which have happened in the recent past, then some of those some of the the activities of the law enforcement organs include torture.
Yeah.
So therefore, you would also be violating the freedom from torture, and you'll also be violating freedom from inhuman and degrading treatment. And therefore, if the people are unable to express themselves, if the people are unable to demonstrate, then in effect you hold them in servitude.
Yeah.
So as much as Article 37 is the one which guarantees demonstrations and picketing, the infringement of that right cuts across and basically negatively affects the enjoyment of very many other rights. For example, the right to life. You can only enjoy the right to life. Your life can only be meaningful if you are able to express yourself.
Yeah.
If you are unable to express yourself, or if you are prohibited from expressing yourself, then your life becomes meaningless. And that then also affects a freedom or liberty. If you're unable to express yourself, then you have no liberty. You have no freedom. And again, therefore, it then means that as a human being, your life becomes not very meaningful. Okay, so therefore, the Constitution should be understood holistically, broadly, and that the violation of the right to demonstrate is not just infringing on the right to demonstrate. You are infringing on very many other rights. And you may also want to appreciate that the state, under, I think, Article 19, has an obligation to respect and adhere to the Constitution. And that the President, under Article, I think, 131, has an obligation to report to the National Assembly on the progress made in realizing, for example, our obligations under the international, our international obligations.
Yeah.
And our international obligations would mean obligations relating to international human rights instruments, whether it is the UN Charter, whether it is the Universal Declaration of Human Rights, whether it is the International Covenant on Civil and Political Rights, or on economic, social, and cultural rights, and within the continent, the African Charter on Human and People's Rights, regionally, the treaty establishing the East African Community.
Okay. Now, you've touched a bit about some of the violations that can be found during demonstrations. Perhaps, what are some of these violations that can be cited to put in place a solid case in terms of somebody wanting to sue the state or sue the police officers in terms of issues of demonstrations, given that the state and the police officers failed to guarantee some of these rights?
Now, the Constitution allows individuals to petition the High Court where their fundamental rights and freedoms have been violated. And again, those violations could be from, infringing on freedom of expression, freedom of association, freedom of assembly, freedom of picketing, so long as there is evidence to demonstrate that the state indeed did violate those rights. And I think in the modern world, where social media and social media is a very powerful tool, there has been many documented incidents where you see police officers raining rungus on a helpless man or woman, or breaking into a house and tear gassing a family where there are children. So those are sufficient pieces of evidence which would be used in a court of law to prove that the police has indeed violated some of those fundamental rights and freedoms.
Okay. Now, the Azimio Umoja One Kenya Coalition has based some of those failure by the state to protect and to infringe some of the human rights to the International Criminal Court. Perhaps for an opposition coalition to move to that extent, does that mean that given the state is culpable, that particular quest for justice can only be found in the International Criminal Court?
Now, I think what one must first appreciate is that persons are free to petition various judicial fora. Okay? But again, there are also legal requirements, so that, for example, before you go to, for example, a higher court, you must demonstrate that you had already gone through a subordinate court, possibly the High Court, depending on the subject matter, because the High Court has original and appellate jurisdiction.
Yeah.
So therefore, there are matters which you can directly move to the High Court under the Constitution, violation of human rights among them. Subsequently, then, if, for example, you feel that you are still aggrieved, you are not satisfied with the decision of the High Court, you can move to the Court of Appeal and subsequently to the Supreme Court. Now, in the area of international criminal law, and and I think that is possibly what Azimio is alluding to, that there has been violation of international criminal law.
Okay.
Okay? It is not violation of the penal code.
Okay.
It is international criminal law. So therefore, the right fora would be the International Criminal Court.
Yeah.
But the International Criminal Court is a court of complementarity. Ordinarily, it is a matter which would be heard at first instance within the jurisdiction of the state. But where the state does not have the relevant law and the relevant court, then that would give a basis to move directly to the International Criminal Court. In the year 2007, Kenya did not have the relevant law.
Yeah.
It did not have a properly constituted court, with the of the standard required by the international judicial organs.
Yeah.
So therefore, there was no law and there was no court. Okay, and then the crimes which were alleged to have been committed were not known to our law. For example, crimes against humanity, you do not find it in the penal code. Genocide, it is not in the penal code. Okay, so therefore, even if we had wanted to prosecute, it was not possible because in law they say there is no crime without a law. Okay, there is no crime without a relevant law. You must say that
this is the law
you have violated, you have committed this offense contrary to this particular law. So after 2008, we then had the law. There is the International Crimes Act. That is now a law which recognizes genocide, it recognizes crimes against humanity, it recognizes war crimes. So therefore, it is possible now to cite. But to date, we don't have the relevant court. We don't have a court properly constituted to deal with international crimes. So, and for that reason, we could still have to, refer to the International Criminal Court. So then, what AJWANG then would have to demonstrate is that whichever crime they allege to have been committed, that those acts would have to correspond with the definition of that crime. So that, for example, if you're saying genocide, genocide has has a threshold. It has a definition. Okay. So, for example, if somebody is to enter into the studio here and slaughter us, then somebody says that there is genocide, that would not amount to genocide, because we do not have specific qualities which make us, homogeneous. For example, we may not come from the same community. Okay, we may not be the same gender. We may, and the same social group. And even if you are to, even if you are to, for example, say that there was genocide, then genocide, the definition would mean that you wholly or partially eliminate a particular group. So if a group, for example, if an ethnic group is a million, and you kill 2 or 10 or even 20, then that act does not have the capacity of eliminating them, whether wholly or partially.
Okay. Now, looking into the issue of human rights violation, and now that AJWANG might be moving to ICC because they are citing the International Crimes Act, in the human rights violation and looking into the issues of the penal code, given that the state and the National Police Service, in this case led by the Inspector General, are, culminated, are sort of cited to have violated some of these rights, does it mean that the lack of faith in the courts that we have in the country sort of propel this particular discussion to the International Criminal Court, given that even in 2013, when we had demonstrations, people are talking about the ICC coming to investigate what is happening in the country and finding those who are culpable. Is that the situation here?
Now, again, the crimes which AJWANG alleged to have been committed, in my view, would be, for example, crimes against humanity. And crimes against humanity, the definition would be, a widespread, systematic, attack on civilians. So there would be that idea that it is widespread, that the attack is widespread, it is systematic, and it is on civilian. Okay, so you must. So therefore, if you break into one house and you leave, then there is nothing to show that it was systematic, and there is nothing to show that it was widespread. But for example, if AJWANG is able to demonstrate that, for example, in a particular region or in a particular area, there was a systematic attack, from door to door, door to door. it was systematic, it was widespread, and it was on civilians, then that would be a strong case for...
Second break now. But once we return, we'll be giving you much more details concerning the issue of police brutality and who should be found culpable in those situations. So do stay with us. We'll be back with more.
For 3 years since the inception of Kenyatta University Women Economic Empowerment Hub, famously KU Hub, thousands of women have been empowered economically through research conducted by Kenyatta University scholars.
Sasa unajua wametufunza sasa tujue hata wamama wanaweza simama mahali wanaume wanasimama.
Kwa hiyo biashara yangu ya poshomi, nimejua nikifanya leo, yani, you know, I'm selling maize na kushaga. So jioni nakuja kufanya hesabu, nitoe expenses, nione income yenye nimepata, ni safe.
KU Hub partners with different stakeholders in implementing research ideas through decision and policy making at county levels.
As we influence policy ourselves, we use data for policy. Also use this data for fundraising, which they are doing.
Through their leadership and governance project, KU have visited Bomet County for research to reach their one objective of empowering women in leadership.
Nimejaribu juzi kuania kiti cha director Kenya National Chamber of Commerce, and thank God I was elected, being a woman. And again, I've got other leadership positions yenye nimepata.
Do not miss out on this special feature this Sunday on KU TV at 9 p.m.
Welcome back. You're watching Law Matters. Tonight we are looking into the issues of human rights and demonstration. This is the final segment of this particular show, of course, bringing the discussion to a close concerning the issue of human rights. Now, Dr. AJWANG, we left the discussion concerning the issue of ICC and the violation of human rights. When we look into the threshold that a bench of an international court being formed to listen to a case, what is the threshold particularly, given that even locally you will hear a bench say that there was not enough threshold for this particular petition being presented in court? What then happens when the discussion is moved to that particular platform?
Thank you very much. The first thing which possibly our listeners should appreciate is that there are various ways of referring a matter to the International Criminal Court, and among them is by the reference can be made by the prosecutor of the International Criminal Court.
Okay.
And that is what happened in the year 2007. The Kenyan case was referred to the ICC by the prosecutor, Luis Moreno Ocampo then.
Yeah.
The other way of referring a matter to the International Criminal Court would be by way of the state itself referring a matter to the International Criminal Court. And a good example is the case of Uganda.
Okay.
Uganda did refer the matter or the cases relating to the international the violation of the statute of the International Criminal Court itself. The other would be by way of the Security Council. The United Nations Security Council also has the power to refer matters to the International Criminal Court. And I think an example would be the case of Sudan. Okay, the case of Sudan, it was referred to by the Security Council. And considering that Sudan is not a party to the Rome statute. Now, the threshold for reference is where, for example, the prosecutor, comes to the conclusion that there is likelihood that crimes or acts known to the International Criminal Court may have been committed. Okay? Yeah. So, coming to that conclusion that there is likelihood, okay, that there is reasonable likelihood that acts prohibited by the Rome Statute may have been committed within that jurisdiction. And that will also then be based on evidence. Okay? So, for example, and the challenge here is that getting evidence, gathering evidence in a state where the state is also implicated is not easy. And I think for that reason, then the threshold is not also very high. Okay. Because, if a person wants to gather evidence against the state, then that person is seriously disadvantaged. And that person also risks their life or their life. But there are instances where civil society groups gather information. There are instances where, for example, the clips which have gone round are put together, and that that then becomes a basis to believe that there is likelihood that acts which are prohibited by the Rome Statute may have been committed within that jurisdiction.
All right. Now, when we talk about the issue of state and gathering evidence against the state, the defense by the Inspector General of Police, Japhet Koome, as well as the state, that is the president and his deputy, is that in the cases where we have had demonstrations, the police acted to protect themselves. But there have also been the debate that what kind of protection were they given? Do you fire a bullet because somebody was carrying a stone? It therefore begs the question, who were the police culpable for some of these cases to the extent that people had to die? Were the protesters so armed that the police had to protect themselves by taking another person's life? How does that bring an equilibrium or sort of balance in such situations?
Now, what is important here is the question of proportionality. Was the reaction of the police proportional to whichever threat that may have been posed? And if you're able to answer the question of proportionality, then you can have a sense as to whether there was use of excessive force or not. For example, if I have a stone and the police is wielding a baton, has tear gas, has a gun with rubber bullets, etc. And I'm one individual and the police are maybe 10 of them. The question would be, is that person posing such a threat that he must be shot? And for example, I think there was an instance where a person was shot 9 times. Okay? So the question is, and this is a person who does not have arms. So it is clear that that threat was not proportional to the response. Okay? So I think the question of proportionality is important. And I think in many instances it is clear that the use of force is excessive. Or for example, when you shoot at a person who's running away, a person running away is not posing any threat to you.
Yeah.
So if that happens, then it is in breach of the Police Act, it is in breach of the Constitution, it is in breach of fundamental rights and freedoms, sanctity of life, etc., etc., etc.
So, Dr. Ajwang, when you want to escalate some of these cases to the International Criminal Court, and looking at how that Hague-based court has handled cases in other countries, there's always been the challenge of the culmination of those particular cases. Sometimes justice somewhat appears to seep through. It never gets to the satisfaction of the aggrieved parties. And case scenario being the 2007-2008, the conclusion of those cases were not to the satisfaction of aggrieved parties. Given that it's an international court, does it now hinder the granting of justice to some of these cases, even as a country sometimes we might feel we want to escalate the cases to that particular court?
Well, the International Criminal Court also has its limitations. And part of the limitations of the court is that the court, in many cases, is involved with cases where the state appears to be complicit in a crime. And therefore, the question of how to ensure that a state or person or individuals who are powerful within the state are brought to account, that does pose a challenge. But at the same time, even that said, it is also true that leaders also appear to be, leaders also to some extent appear to respect the court and would not want to appear before the International Criminal Court. So therefore, the existence of the ICC is also a deterrent. And then there's also the sense that, for example, a leader, let us take, for example, our country, Kenya, the immunity from prosecution is only during the time when you are in office. Okay? So your immunity from prosecution is only when you are in office. Once you leave office, then you can be prosecuted for any act which you may have committed while in office. Now, and then thankfully, the statutory limitation period begins to run after you leave office. Because there are, acts which are time-bound, but criminal acts are not time-bound. So that even 20 years down the line, 30 years down the line, if there is evidence, you can still be brought before before the court. So I think that is also a deterrent, because even if you are in power, then you would be in power for a limited period. 20 years after you leave office, it is still possible to revisit
waiting for you.
Yes, that matter, and you can find yourself before court. So therefore, the International Criminal Court has a deterrent use or effect, and therefore that is useful. But the challenge in many instances also does arise if it is in relation to a powerful state. For example, the United States or Russia. For example, it has been, the successive American presidents alleged to have committed international crimes by having, by invading other countries and perpetrating acts which would amount to international crimes.
Right.
But America being as powerful as it is, how do you, for example, go to, how do you, for example, arrest Obama or, his predecessor, etc. So therefore, but I think that is not unique to international criminal law.
Yeah.
Even national law, it is true that there are individuals who are powerful within the country and are able to get away even with crimes.
Yes. Now, Dr. Jung, because of time, as your parting shot, do you think human rights have been enshrined during demonstrations here in the country, especially political ones, since time immemorial, when we used to have, the Sabasaba demonstrations? How are we coming so far, even with the promulgation of the 2010 Constitution?
There was a sense that there was movement, particularly after the promulgation of the 2010 Constitution. It appeared as if, there was a movement towards, a country which is governed by the rule of law, a country which due process is adhered to, and that hope or that movement appears to have been interrupted.
Okay.
And there is now a sense that we are going back to the dark days when demonstration was deemed to be, an affront against the state, where demonstrators were deemed to be like the enemies of the state, and where there were orders, shoot to kill.
All right.
Okay, orders.
Thank you.
So therefore, it appears that the gains which we may have made after the promulgation of the 2010 Constitution today appears to be under serious threat.
All right. Thank you, Dr. Ajwang, for your perspective concerning this particular topic. Of course, it is a discussion you can have more and more, looking into the different situations we are having as a country. Now, that's it for Law Matters tonight concerning the issue of human rights and the demonstrations. But before I leave, let me read some of your feedback sent on our social media platforms. We have Ronald Momanyi on YouTube saying, great articulation of fundamental freedoms and rights. We have Ian Mulei saying, quite the elaborate explanation by Dr. Ajwang. I wish it be so clear to the masses. Thank you, Ronald and Ian, there for your perspective and your feedback concerning this particular show. Because of time, I wouldn't add too much to it. You have had it. We have brought the discussion to a close. Many thanks indeed for tuning in to Law Matters. Have a splendid night. My name is IRENE MWANGI.
Kutoka kuwa jamii ya kuhamahama na sasa kujumuisha kilimo katika mitindo yao ya maisha. Kwenye toleo la kaunti ya Narok, hii ni Boresha Kilimo, kwani afya bora ni kilimo bora. Kwani kilimo ndicho huboresha maisha.